Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with the phrase survival of contract. What does it mean if something survives the contract, and why is that important? So let's discuss this. So in essence, if something says, if you read in a real estate contract something that says it survives the contract. The survival clause really means that whatever that provision is remains in effect after the termination, expiration, or closing of a contract. In other words, the obligations of the parties to perform that specific issue that is stated that survives the contract is the obligation is still incumbent upon the parties to do whatever it is they said that they were going to do. Another way of looking at this is if the party states that they are going to do something in a contract and they do not do it in a contract, and that provision does survive the contract, that gives an attorney a contractual basis to make an argument on behalf of their client that that is still an obligation that needs to be performed per the agreements in the contract, even after it has closed. So, why is this important? Well, depending upon the contract under which the parties are binding, there are different provisions or clauses or obligations that survive the contract. In other words, there are certain provisions that once it is closed, terminated, or ends, there's no more obligation to act on behalf of anything that was agreed upon in the contract, unless that survives a closing in which the obligation does exist. And so the remedy, if the party does not do that, could be argued in a court that they agreed that provision, that obligation is still incumbent upon the party even after the ending of the contract. So let's look a little more specifically at the GAR, the Georgia Association of Realtors contract, the RE Forms contract, and then a couple of tips for you as a real estate agent, how to protect your clients regarding this contract provision of survival of the contract. So, in both the Georgia Association of Realtors contract as well as the RE Forms, there are, as well as other contracts, you're going to have to read each contract. A builder's contract is going to have different things that survive. A HUD contract is going to have different things that survive. Fannie Mae, Freddie Mac, purchase and sale addendum is going to have different things. An attorney written contract. This is specific to the contract and the agreements between the buyer and the seller. So in the GAR contract, we'll start with that one. There are various things that within the contract in and of itself where it talks about that, there is survival language within other paragraphs. For example, commission survives the contract, and that is spelled out in the commission paragraph, the obligation to pay commission, so forth and so on. But overall, what the GAR, Georgia Association of Realtors Purchase and Sale Agreement states, and that is Form F201, under paragraph C4I, survival of agreement, it outlines very, very specific things that survive the contract. It states the following shall survive the closing of this agreement. Number one, the obligation of a party to pay real estate commission. Number two, any warranty of title. Number three, all written representations of a seller in this agreement regarding the property or neighborhood in which the property is located. Number four, the section on condemnation. Number five, the obligations of the parties regarding ad valorem real property taxes. And number six, any obligation which the parties herein shall, I got to make this bigger so I can read it. Any obligations which the parties herein agree shall survive the closing or may be performed or fulfilled after the closing. This is key for you as a real estate agent. So let's talk about this and what this means. Again, it says any obligation which the parties herein agree shall survive the closing. So let's first talk about what's not in that survival definition in the Georgia Association of Realtors contracts. Is there anything in there about a seller's obligation to pay for a home warranty for a buyer? Nope. Is there anything in there about a seller's obligation to perform repairs? Nope. So those issues, those items in and of themselves do not survive the contract, meaning there is no longer that obligation incumbent upon, in my example, the seller to do that after closing if the parties did not specifically state that they agree those provisions, those agreements shall survive closing. So what do? As a real estate agent, you need to remember the magic phrase. The magic phrase, and you've heard this if you've been in my classes before, the magic phrase is, this provision shall survive closing. What that does when you are writing that provision in the contract and add that phrase, that all of a sudden ties it in to what is stated in the GAR contract number 6. Now that is something that the parties agree shall survive closing. So let me give you an example. Let's say that a buyer and a seller negotiate for the seller to pay for a 1-year home warranty for the buyer at closing and to be ordered by whichever agent, so forth and so on. Well, it never gets ordered. It's just an oversight. It never gets ordered. The property closes. There's no home warranty that has been ordered. So the buyer calls the buyer's agent and says, hey, where's that warranty? I need that information, the policy number. What do I do? So forth and so on. And the buyer's agent goes, oh my goodness, we completely forgot. Let me call the listing agent and get them to take care of that so the seller can pay for that. Buyer's agent calls the listing agent and says, funny things, it's great working with you. We forgot to order the home warranty. So I need for you to call in and get the seller to pay for the home warranty for the buyer on that closing that we just closed on 2 weeks ago. And the seller's agent says, so sad, too bad. We've closed. That does not survive closing. Buyer's going to have to pay for it themselves. And the buyer's agent says, so sad, too bad. I took Dana's class, or I watched Dana's video, and remember, we wrote the magic phrase, this provision shall survive closing. So the obligation is still the seller's to pay for it. So then, of course, the seller's agent calls it in, seller pays for it, it's all done. So again, that is one example. Repairs. How many times have a buyer and a seller negotiated for repairs? You do a walkthrough and they are not done. I have done several videos on repairs and the major problems with what happens if a seller does not do those. And I'll link that video below. I will let you know that termination rights for a buyer without penalty is not necessarily a remedy for a seller not completing the repairs prior to closing. So again, I'll link that video below. But this is very key for you guys in issues like that to add that phrase, this provision shall survive closing. Again, hopefully the parties will perform, but if not, at least it gives the attorneys the contractual groundwork to argue the case for that obligation, even after the contract has closed, been terminated, expired, so forth and so on. Now, I want to thank Seth Weissman of Weissman Law, closing attorney in Metro Atlanta, and I believe throughout all of Georgia, for adding something to that phrase that actually I had not considered until interacting with Seth. And what that is you need to add a time frame to that. So in other words, let's say you're writing a special stipulation, continuing on with my example, about the seller's obligation to pay for a 1-year home warranty for a buyer. And you're going to add in, this provision shall survive closing. Now you need to add in a time frame. So what you should say is, this provision shall survive closing for a time frame of up to 1 year, 6 months, 2 years, something like that. When you're, for example, negotiating for repairs, one of the time frame might be different for a seller to complete repairs than it would be for negotiating for a home warranty. But I want to thank you so much, Seth, for bringing that to my attention, that you definitely want to put some sort of a time frame on how long that will survive closing. Now, obviously, warranties of title, so forth, and commission, that is going to survive. But when it is something that the buyer and the seller are contractually agreeing to regarding performance, you probably want to add that time frame. Now, let's look at the RE forms. In the RE forms, and for whatever reason, a lot of agents refer to those as the FMLS forms. I'm not quite sure why, because agents have access to those through a number of MLS systems, including Georgia MLS. But nevertheless, in the RE forms, this is spelled out in the standard terms. And in the standard terms, that is RE1 standard terms, and it is under paragraph. Let me make this a little bit bigger so I can see. This is under paragraph 12 under the standard terms in the RE forms. And it is specifically, it is paragraph 12.7, where it states, unless expressly agreed otherwise in the contract, or unless provided otherwise in any other document executed by the buyer and the seller at or prior to closing, the provisions of the contract shall survive closing. So what does that mean? Well, that means that unlike the GAR purchase and sale agreement, where it is only those 6 items that survive the closing, if the parties are binding under the RE forms, the entire contract, the obligations and the promises the buyer and the seller made to one another survive the closing, meaning even after the transaction is closed, if something had not been completed prior to closing, there is still a legal contractual obligation for that to occur even after the closing. So that is a pretty large difference between the GAR, Georgia Association of Realtors Purchase and Sale Agreement, and the RE Forms Purchase and Sale Agreement. So just briefly wanted to bring that to your attention, what a survival clause is, what it means to you, why it's important, and how you as a real estate agent need to take a look at that in the contract that your buyers and sellers are signing. Again, if you are helping your buyer and your seller with a contract that is another contract, like I said, a builder's contract, a HUD contract, so forth and so on, you need to understand what survives closing and what does not survive closing. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.